it may have been that Mr. Pearson may have had was communicating with staff more, and that's why it was put that way. All right, so we're in good shape now. I have what I need.
Your Honor, we have others for Metro Green, including co-counsel. I didn't know. I had thought. I think
if only you're speaking, that's fine.
Yeah.
If it's only you today.
We have other counsel. I think I'm going to be the only one speaking.
All right. So if anyone plans to have any discussion, or to be heard today, then you need to turn on your mic and let me know. Otherwise, I'm completely fine. And we can proceed at this juncture. So I'm going to now call the calendar. This is 24 CV 5245. This is the matter of Metro Green Recycling LLC versus the City of Stonecrest. For the Metro Green Recycling 3, we have Mr. Richard Robbins, and for the City of Stonecrest this morning, we have Mr. Winston Denmark. All right. So initially, we had the we had the complaint or petition for mandamus that was filed on the 22nd, and according to the rules, the court had to schedule this within a certain time frame. So I think that's the reason why we placed it on the calendar for today, for July 3rd, so we can handle that issue. But then I received another, I think it was a motion. Yeah, we received a motion to dismiss, and that was filed on the 26th. I was thinking that we were going to get a response to, my intent was to have that response in for the writ of mandamus, which I'm thinking, okay, wait a minute, there is an answer that was filed likewise on the 26th.
Yes, ma'am.
Yeah, so those things were not briefed. The brief in opposition, we have not reviewed that. It came in on the 2nd. I'm having someone look at it now to provide notes, but I have not reviewed it. Okay.
Okay.
All right, so I have it up though. So I have all the current documents up. All right then. Ms. Robbins, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Yes, and we filed a response brief to the motion to dismiss yesterday. Sorry for the tight timeline, but that's
we knew we were on the tight timelines. Yes, I understand. I just haven't had a chance to look at it.
Absolutely, and it's very, very eloquent. So I hope you have the opportunity to look at it. And we also filed yesterday certain affidavits with exhibits attached, an exhibit list, and the hearing exhibits, because we weren't sure. The hearing exhibits are duplicative of what's attached to the petition, verified petition, and the affidavits. And we put that all in the record because, frankly, we think this can be decided on exhibits which cannot be disputed. They're almost all communications between the city and Metro Green. So it's hard to argue about those. We put them all in the record to avoid the time of any testimony, although, of course, Mr. Denmark's free if he wants any witnesses to examine them. But I felt, we were respectful of your time, and we tried to put things in that were not disputed and could not be disputed, as well as the certified ordinances. So we filed all that yesterday. So I just wanted to make it clear that the hearing exhibits, the documents marked as hearing exhibits, other than the certified ordinances, are already attached to the petition or to the affidavits for your Honor's consideration. So we tried to get everything before you and make it efficient. Mr. Denmark yesterday confirmed that the certified ordinances provided to the city and submitted to your Honor were self-authenticating and correct certified copies. He can confirm that, but we got an email from him yesterday. So there should be no issue on the ordinances either, your Honor.
Okay.
Second, just for the record, I'm Richard Robbins with the law firm of Robbins, Alloy, Belinfante, Littlefield. And with me is my colleague, Casey Bain, who is counsel record from our firm. We also have on this Zoom conference, Lee Tucker, Matt Benson, and Brian Easley, who have been before your Honor and are still on prior matters and are still co-counsel for Metro Green. I don't anticipate they will need to say anything. If they do, they're certainly here at your disposal. And finally, we have Mitch Stevens, who's the CEO of Metro Green. I didn't my law firm didn't make an appearance until after the injunction rulings, and then we took the lead on the appeal. So this is my first opportunity to address Your Honor on this case, in case you're wondering where did we come from. But we came in after the, after Your Honor's decisions.
So were you a part of the appeals process, or you came, or is this your first appearance on the mandamus?
Well, no, I came in at the appeal process.
Okay.
And I think we even filed a couple of things before Your Honor. And then we were the lead counsel on appeal. And then we filed in the other case. I should make that clear. It's been a little confusing. But in the other case, and then we are lead counsel on this action, which is a mandamus.
Okay.
So I just wanted to give you that background, because there's been a lot of activity, to say the least.
Mm-hmm.
And one thing we're trying to do, quite frankly, is to try to forestall yet more action that requires your court's attention and requires more legal disputes between the city of Stonecrest and Metro Green. As I said, we're relying on the verified petition and the attached exhibits, the affidavits with the exhibits attached, as well as the certified ordinances. We really thought that when the Court of Appeals reached this decision rather decisively, reversing Your Honor, as trial judges always tells me, well, that's what appeal judges are for, and like it or not, sometimes they affirm and sometimes they reverse. And as you know, they just firmly reversed Your Honor's injunction, permanent injunction entered against Metro Green, entered on behalf of the city of Stonecrest, and they reversed the preliminary injunction entered by Your Honor on behalf of Chase. And I think it's important to note, and it will be for the argument, the Court of Appeals did not reverse or vacate and remand to you for consideration of whether there could be other factors as a basis for injunctive relief or basis for the city's claims. They flat out reversed. As you know, sometimes they think there are other grounds that may be applicable. They just did that recently to everyone's chagrin in some other cases, and tell you to consider other bases, for an injunction or a preliminary injunction. They didn't. I mean, they made their position clear. No injunction, no preliminary injunction. That's it. And they took the issue of solid waste management out of the case. I mean, that was at the core of the city's arguments all along. And they very squarely held was the city issued a letter saying we complied with the solid waste handling regulations. The EPD relied on that letter as well as its own evaluation and issued a solid waste permit. And that's it. And we respect the opinion, and I know Your Honor respects the opinions. And what we are, and I really thought after that, I've been involved in dozens and dozens of permit and zoning cases. I'm sure Your Honor has had the misfortune of being involved in dozens of these cases as well. But, I find that typically once an appellate court rules, everything kind of goes smoothly, and the permits are issued, zoning is approved, rezoning is approved, and people go on. And unfortunately, that's not what happened here, Your Honor. What happened was we, citing the Court of Appeals opinion, resubmitted our renewal for business license, recognizing that the business license was granted back in 2019, reviewed 2020, reviewed and renewed 2020, renewed again 2021, and there were no issues. And then they got into litigation and stopped doing anything with this project, which has sat unused for 3 years. A $20 million project is sitting there doing nothing for years while this litigation has been going on. And I'll walk through this quickly just so this is all in the record, but we filled out the form, renewal form. It's online. It doesn't even say who you send it to, which is an issue with the party I'll address briefly. It doesn't say who to send it to. You fill out the form. we submitted it, and this one was a bit different, so we submitted it under a lawyer letter saying, and enclosing the Court of Appeals decision, so there's no issue. That was that the reasons that the city earlier gave for not renewing the business license had been rejected by the Court of Appeals. We filled out the form for a certificate of occupancy back in 20 and 21. And again, I'll go through these documents quickly, or as however your honor prefers. We asked for a certificate of occupancy to the building department. I think it was building. And we had gone through the process in 20 and 21, and all the criteria had been met. And you'll see that all the inspections had been done by the city, signed off on by everybody, including the DeKalb County Fire Department. So everything had been done. All the criteria had been met for their certificate of occupancy. And then when we got to the litigation, they just said, no, we're not doing anything. So we asked for it at long last to be issued, but all of the criteria that the law requires, that the city's own code requires, have been taken care of, and have been taken care of since 20 and 21. But we filed, again, there's a checklist, Your Honor. You've seen many of these checklists. You probably maybe filled out some yourself. It's not rocket science to fill out, to check off the boxes on the applications for the business license renewal, the applications for a certificate of authority, and you submit all that, and then it's got to be approved. I mean, that's it. Or they have to, the city has to articulate the reasons why the application isn't approved, and then that's important, because then perhaps somebody forgot something, and then you can say, okay, well, I'm sorry, I'll send that to you. I mean, that's the normal course of getting a business license and certificate of occupancy, and it's accepted, officially accepted, reviewed. If everything's there, it is to be approved. It's not a discretionary act. This city, like most cities and counties in Metro Atlanta, no telling how many they process and approve every week, or indicate you forgot to enclose something, close it. So we submitted it after the decision. They sought certiorari before the Supreme Court. The Supreme Court flat out denied certiorari. And then we waited for the remitter, which was made. So that is law of the case. In terms of no injunction, the arguments that they raised were rejected by the Court of Appeals, and at a minimum were not referred to you as alternative bases to consider for the relief that the city has sought. So that is the process we went through. And like I say, I'll run through the exhibits, but they're all in the record. But what we got, instead of hearing from anybody at the city staff, city administrator, anybody handling our business license renewal, or anybody handling the certificate of occupancy, nobody with the city said there was anything wrong with what we submitted, that we left anything out, gave no reasons at all for any action. All we got is a letter which is marked as exhibit number 13 to the petition, and is also here in exhibit number 13, is a letter from T. Orlando Pearson, the council at the time, dated May 10th, 2024, responding to our demand for issuance of certificate of occupancy and application for renewal license. Not saying who was authorized, who at the city was actually making the decisions set out in the letter, if anybody. We don't know. That was one reason why it's very difficult to name particular people. But Mr. Pearson, on behalf of the city, stated none of the reasons that are set forth in the city's motion to dismiss as bases for alleged denial of our applications. And that is important. None of those reasons will you find in the letter from Mr. Pearson, exhibit number 13, which was the only response from the city. This was so unusual for us that the city itself did not take action, but relied on its council to take action, that we even sent an email to Mr. Pearson, which is an exhibit to my affidavit in the record, saying, we're not understanding. You're standing on legal arguments that the Court of Appeals rejected. Has the city accepted the applications? Have they denied them, or have they not taken any action? There's a certain process a city is required to follow. We got no response to that letter, and I stayed in my place, and I also put in my affidavit. We got no response to an email, which is, what is the city doing here? But these are the only reasons that the city has offered, which stand in the way of approving our business license renewal, as well as our certificate of occupancy. No issues with the applications, no issues with things left out, nothing. What Mr. Pearson said was, on January 2022, the Superior Court enjoined Metro Green, as well as Metro Green's agents, servants, employees, and all others from inter alia constructing, occupying, or operating the subject facility. As such, the sought-after certificate and license would be void ab initio. Likewise, the demand and application are moot because they were allegedly rendered void by Your Honor's injunction. There is a rather obvious fatal flaw to that response, which is that the Court of Appeals reversed your injunction, period, and stop. And so the city's sole reason for refusing to issue the business license renewal and the certificate of occupancy is a legal error. It is relying solely on the base of Your Honor's permanent injunction, which was reversed. I cannot explain why the city's attorney would make the sole basis for their action to be a injunction that was reversed. But
where did the city respond to you? Where is that in your exhibit? Their
response? It is. I'm sorry, Your Honor. I didn't mean to cut you off. It's the petition for mandamus, Exhibit 13, which we also
13. Okay, yes, get there. Okay, I was trying to find it. Okay, go ahead. And feel free to interrupt me. I'm trying to speed along because I didn't want to spend any more time than Your Honor was able to devote to this. But this is the only response we got from the city to our application, and the only reason given by the city is your injunction, which was reversed. I don't know how plainer I can state it, that this is such a demonstrably wrong basis for refusing us a business license renewal and certificate of occupancy. I do not know. The city has said, well, we haven't named all the proper parties. Well, Your Honor can take care of that. I'll get to that in a minute. But our problem is we don't know who at the city is behind this. We don't know if they were reporting to the mayor, the city council, the building official, the planning director, or who. And Mr. Denmark is free to educate us. And Your Honor has, of course, the authority to add parties, the right parties when it comes to governments. But this was on behalf of the city, and that's it. That's the only reason they cited. And now in their motion, for the first time, they argue all sorts of a grab bag of other arguments. The problem is that ship has sailed. The courts have held repeatedly, a city has to follow its objective criteria. They can't come in after the fact and say, oh, well, you don't like that? Well, try this one, when you get to court. It would be a never-ending legal process if the city or a county came back and said, well, okay, that reason didn't work. Well, we've got 5 other reasons we can offer. And that's what they try to do. And they didn't do that by way of any kind of administrative ruling that could potentially be appealed. They just did that by way of response to a mandamus. But there will be nothing in the record showing that anything other than Mr. Pearson's statement on behalf of the city was a basis for denial or inaction, let me say, on the issuance of the permits and COE. I frankly think that's the end of the case. Your Honor can see quite clearly legal basis for failure to issuance is wrong as a matter of law. One can't rely on a trial court's order that has been reversed. So that is why we are here. And
in the letter, Mr. Pearson also unfortunately stated that the city, despite losing dispositively in the Court of Appeals, stands to continue to prosecute the above referenced matter to prevent Metro Green's operations in the city. It is like the Court of Appeals never ruled. Your Honor's not going to disregard the court order. I am certainly not going to disregard the appellate court's order, but the city has chosen to treat that as not relevant and instead rely on this court's orders, even though they were reversed. I mean, I think that could be the end of the mandamus claim right here. The city relied on a wrong reason, not a reason in the ordinance, which the appellate courts have held time again. You cannot do that, city or county. You cannot rely on reasons outside of the ordinances. And that mandamus must be issued when a city or county attempts to do so. And we've cited multiple cases along those lines in our response brief, which I know you haven't had a chance to review unless you wanted to stay up all night looking at it, which I felt comfortable. You wouldn't do.
I was not even aware that it was filed.
Okay.
So no, I didn't even know it existed.
I was kidding. We did send you courtesy copies as directed by your office to two people, but I knew that you wouldn't have the opportunity to read it. But I wanted to tell you everything that I've just talked about is stated more succinctly with case cites in our response brief. Right. And clearly, if Your Honor has any other legal issues that you want us to address before you rule, we are more than happy to do so on an expedited basis. My colleague and I were here late last night, making sure everything was in the record for Your Honor to consider.
Right. I'm interested in hearing Mr. Denmark. I want to know what distinctions and what your position is. I was quite surprised too to see the mandamus on the issue, and I was trying to before you had even responded, I was trying to figure out what the position was that the city was taking. So yes, I would like to hear from you.
Yes, ma'am. And good morning, Your Honor. Thank you.
Can you turn your volume up just a tad bit for me, please?
Yeah, I'm actually on my cell phone because I was having a problem with the audio, with the video on my desktop. So I don't know if you can hear me or not.
No, I can if I kind of struggle a little bit. That's what I was wondering. Is that the loudest the
yes,
louder the volume will go?
Yes, it's actually I'll try to speak as loudly as I can, but
well, hold on a second. Let me just make some adjustments in my office. I had a fan going, and so maybe that'll help me be able to hear you better.
Yes, ma'am. Well, let me start off by saying that we do not believe that mandamus should issue in this case. I believe that there is a fundamental misunderstanding about where we are in this process. If you start in 2024, you don't appreciate where we've been with regard to the business license and CO applications, certificate of occupancy. Your Honor, Mr. Robbins went through considerable length in his oral argument today and in his written submissions talking about the opinion of the Georgia Court of Appeals on the solid waste handling permit issue. That's not really relevant to the issue of the business license that Metro Green is seeking. Mr. Robbins makes the point that the only reason asserted for the denial was the injunction from this court in the solid waste handling permit case. But that's patently false. Going back to 2001, the city of Stonecrest has told Metro Green that their facility is in violation of city ordinances. And
you said 2001, or you mean 2021?
I apologize, 2021. I apologize, Your Honor. From 2021, we have told Metro Green that they are in violation of city ordinances, and those city ordinance violations, nonconformities, was the basis for the denial. You know, if you would just bear with me just briefly, I want to go through the regulatory scheme that governs this matter. Business licenses in the city of Stonecrest are governed by section 15-2-20 of the Stonecrest Code. Business licenses are reviewed by the city manager or her designee and may be denied if, among other reasons, the applicant provides false or misleading information in the application, the premises violate city codes or ordinances, including zoning, or the premises create a threat or nuisance to public health, safety, and welfare. If an applicant is denied a business license, section 15-16-1 provides for an appeal. And this section says if an aggrieved person desires to appeal a decision, a notice of appeal must be filed within 15 days of the receipt of the decision complained of. So if the city denies your application for a business license, you have 15 days to appeal. And I'm going somewhere, Your Honor, if you just bear with me. Appeals are heard by a hearing officer appointed by the mayor and approved by the city council. And appeals from the hearing officer are to Superior Court by writ of cert. So that's for the business license. For the certificate of occupancy, section 7-143 states that the building official must issue or deny a CO.
I'm sorry, what was that? The city occupancy, what's the code?
Yes, 7-143. And that states that the city's building official must issue or deny a certificate of occupancy. And that section also states that no CO or certificate of occupancy shall issue if the structure does not comply with the zoning ordinance. And if the certificate of occupancy is denied, the applicant can appeal to the Construction Board of Appeals, which conducts a due process hearing. As one might expect, appeals from the Construction Board of Appeals are to Superior Court. Well, Metro Green is well familiar with these processes and these codes. In fact, the company has started but not finished appeals of the city's denials of both the business license and the CO. Let's start with the certificate of occupancy. Metro Green applied for a CO in 2001. On May 6th, 21, I apologize. On May 6th, 2021, Carrie Caldwell sent an email denying that application. And this email is in the petitioner's mandamus application as exhibit number 11. The reason was because the facility was not in compliance with local ordinances. So in 2021, Mr. Caldwell said you don't get a CO because you don't comply with the local ordinances. Metro Green followed the law and correctly appealed to the Construction Board of Appeals. Now, the Construction Board of Appeals, and that was in November of 2021. The Construction Board of Appeals ultimately ruled on the CO denial in December of 2021, affirming the denial of the CO by Carrie Caldwell. Not satisfied there, on January the 7th, 2022, Metro Green followed the law and correctly filed for a writ of cert in the DeKalb Superior Court, appealing the decision of the Construction Board of Appeals. Now, the civil action file number on that is 22 CV 1129. On November 14th, 2022, Metro Green made a decision to voluntarily dismiss the Superior Court appeal without prejudice. Now, this decision was presumably based on this court entering an injunction in the solid waste handling permit case. Significantly, Metro Green has not sought to refile its Superior Court appeal to obtain the certificate of occupancy. That would have been its adequate remedy at law. Until this process is exhausted, the mandamus sought here is inappropriate. Now, as relates to the business license, Metro Green also complains about the denial of its application. It cites the 2024 letter, but we have to go back to February 23rd, 2022, when then interim city manager Janice Jackson sent a letter to Metro Green denying their application for a business license. Now, Ms. Jackson delineated a litany of reasons why the facility violated numerous city ordinances. These reasons included non-compliance with the zoning ordinance and creating a public nuisance or threat, which is specifically listed as one of the grounds for denial in 15-2-20. So Metro Green has long been on notice from both the building official and the city manager that their facility violated city ordinances when they sought both a CO and a business license. Now, Metro Green timely filed an appeal of Janice Jackson's denial of the business license. They followed the law then. And so they filed that on March the 8th, 2022. Now, this appeal that Metro Green sought was in accordance with the city policy set forth in 15-16-1. And in the May 8th appeal letter, Counsel for Metro Green listed an enumeration of errors that he would be addressing at the appeal hearing. Metro Green specifically challenged in this May the 8th letter that it provided false information in the business license application. It challenged that it violated city codes and ordinances, including zoning, and it challenged that the facility creates a threat to public health, safety, or welfare. Again, these are the precise grounds for denial set forth in Janice Jackson's denial letter in February of 2022, and these are the precise grounds for denial in 15-2-20. So Metro Green understood that it had to address and overcome these grounds for denial that were firmly rooted in city ordinances, nothing to do with the solid waste handling permit. However, according to Mr. Tucker, the city refused to grant Metro Green requested appeal based on the pendency of the EPD litigation.
I'm sorry, say that again.
Yeah, so the Counsel for Metro Green, and this is from, I'm looking at their exhibit number 12 of their mandamus petition from Mr. Lee Tucker. Mr. Tucker asserts in his letter that the city of Stonecrest refused to grant Metro Green's requested appeal of the business license denial because of the ongoing litigation about the solid waste handling permit. So there was never a hearing on the ordinance violations that caused Janice Jackson to deny the permit, the business license. Metro Green did not seek mandamus to compel a hearing at that time. As I stated earlier, a hearing officer appointed by the mayor and approved by the city council would hear these denials of business license. So if you apply for a business license, the city manager says no, the road doesn't end there. You appeal to the hearing officer pursuant to 15-16-1, and you get the hearing officer to hear your denial. And if you're unsatisfied with the hearing officer's determination, you appeal back to Superior Court. They had an opportunity to do that in 2022 when Janice Jackson denied the license. They had an opportunity to do that in 2024 when they get this letter that let's assume for the sake of argument that was a denial letter from Orlando Pearson. They had and have the opportunity to appeal that pursuant to city code. They've not done that. So they've instead chosen to come and seek extraordinary relief in this court. Now, Metro Green doesn't have an entitlement to that extraordinary relief because as an initial matter, it does not comply with the conditions of zoning. They claim that they have been advised by the city that they comply with zoning. I've just given you two examples, the Kerry Caldwell letter or email in 2021 and the Janice Jackson letter in 2022, where the city says unequivocally, you violate zoning. You do not meet the standards. You lied on your application. You are a threat to public health, safety, and welfare. They've been told twice that they don't comply with the city's zoning. So to pretend here today that all indication from the city of Stonecrest is that they fully comply and meet the qualifications is disingenuous at best. They've been told twice that they don't comply. And not only did they know that, they tried to seek an appeal of those determinations. So they knew they were, and that's why I went to some length to talk about Mr. Tucker's enumeration of errors, because he addressed the fact that Janice Jackson told him, you don't comply with the zoning, you lied on your application, you're a threat to public health and safety. So these were issues that they knew, and so to suggest today that with all systems go is patently false. Now, there's also substantial evidence that both the business license and going back to the solid waste handling permit, but that's not relevant, they were untruthful in the application, that they don't comply with zoning, and that they are a threat based on the environmental danger that the facility represents. These are things that have been presented to them before. Now, the Court of Appeals decision is completely irrelevant. I mean, they place a lot of reliance on that, but this is not a case about a solid waste handling permit. This is a case about a local ordinance. Now, Metro Green must follow the procedures in the city's ordinance in requesting appeals hearings. They want to jump the gun and come here. Metro Green is trying to do an end run on the entire ordinance process. They went through the trouble of getting certified copies of all of these ordinances. They probably should read them. There's an appeal provision there that they should follow. But instead of following the appeal provision set for the city ordinances, they are trying to do an end run on that and come to this court and try to get mandamus relief. Again, they are familiar with this appeals process. They tried to appeal the business license denial in 2022. They actually appealed the CO denial in 2021. And they took that all the way to the Construction Board of Appeals. And when they were not satisfied there, they filed a cert in Superior Court. But they made the decision to voluntarily dismiss their certiorari appeal in Superior Court. That was their decision. So Metro Green wants this court now to compel the actual issuance of the business license and CO. But respectfully, Your Honor, the Superior Court cannot apply the standards or administer the city ordinances. Only the city can do that. Metro Green cites the Court of Appeals ruling like it's some kind of self-wielding, self-executing talisman that entitles them to the business license and the CO. However, the business license and the CO were in no way before the Court of Appeals. There was no ruling by the Court of Appeals on these issues. The ruling of the Court of Appeals is only relevant to the solid waste handling permit issued by the EPD, specifically whether the city exhausted administrative remedies prior to seeking an injunction to prevent operation of the facility under the EPD permit. So absolutely nothing in that ruling from the Court of Appeals touched or concerned certificates or licenses issued by the city of Stonecrest. Again, to get a business license and or a CO, Metro Green is required to submit application to the city, appeal any denial to the hearing officer for business licenses or the Construction Board of Appeals for the CO, and if they're unsatisfied with those determinations, ultimately to Superior Court. Now, importantly, Your Honor, if the city refuses to give them a hearing on these denials, they may have a right to seek mandamus to compel the city to give them a hearing. But Metro Green doesn't want a hearing. They just want you to bypass the entire process and give them the license. Now, Metro Green is seeking to get the certificates and licenses directly from the court. It is ironic and highly hypocritical that Metro Green would resort to this tactic. The core of its argument in this court and on appeal was that the city of Stonecrest did not exhaust administrative remedies. It screamed at every turn that the city should have appealed the issuance of the EPD permit within 30 days. Metro Green also chided Chase for not appealing Director Dunn's letter refusing to revoke the permit. When Director Dunn didn't revoke the permit based on the Chase letter, they said, well, you should have appealed that letter. You should have appealed that. Metro Green vehemently insisted that injunctive relief and extraordinary mandamus relief was improper without exhausting available administrative remedies. Metro Green sternly admonished the city and this court for granting injunctive relief without exhaustion. Metro Green's appeal brief was filled with contempt and exasperation for the city and this court's ruling. And since the Court of Appeals ruling, Metro Green has not missed a single opportunity to chastise the city and take self-congratulatory victory laps now that it believes that its position has been vindicated. Mr. Roberts took a victory lap in his oral arguments this morning. Yet the same self-righteous Metro Green is now in this court asking Your Honor to issue a writ of mandamus when Metro Green has not exhausted its available administrative remedies at the city of Stonecrest. When Metro Green has not sought appeals from the Construction Board of Appeals or from the Business License Hearing Officer, when it has not filed an appeal in Superior Court to demand these hearings. Metro Green is committing the very sin that condemned the city of Stonecrest and this court for committing. It is seeking extraordinary relief without first availing itself of the adequate, available, and familiar legal remedies under the city ordinance. The court should completely reject this shameful hypocrisy. What they should be asking for today is we need a hearing on our business license. We need a hearing on our certificate of occupancy. The city has been telling Metro Green for many years that you violate the city's zoning ordinance, that you lied on your application, that you constitute a threat to public health and safety. These are standards delineated in the Stonecrest ordinance. These are things that Kerry Caldwell told them in 2021. These are things that Janice Jackson told them in 2022. They commenced those appeals, but they made the decision to dismiss the appeal in Superior Court as it relates to the certificate of the certificate of occupancy. They didn't have to voluntarily dismiss. They could have demanded that the court rule on whether or not the Construction Board of Appeals erred in upholding Kerry Caldwell's denial. They could have appealed Janice Jackson's letter when she denied their certificate, their business license. They have every opportunity to say, we want to invoke 15-16-1, get before the hearing officer authorized by the code and get a hearing on your denial. They didn't do it in 2022. They didn't do it in 2023. They didn't do it in 2024. When they renewed their application in 2024, they said, just give us the licenses. And Orlando Pearson sent them a letter. If they think that Mr. Pearson's letter is wrong and does not set forth the grounds for denial of the business license, well, what does the city code tell them they ought to do? Does the city code say go and seek extraordinary relief by writ of mandamus in Superior Court? Or does it say file an appeal under 15-16-1 before the hearing officer? They haven't done that yet. They haven't done that yet. They have not sought the appropriate appeal under the city of Stonecrest ordinance. They want to come to this court and bring up a totally irrelevant case at the Court of Appeals about a solid waste handling permit. Nobody's talking about a solid waste handling permit. The city of Stonecrest has the right to enforce its sovereign ordinances. Just because they may believe that the Court of Appeals gives them the right to have a solid waste handling permit, that doesn't also give them the right to have a business license. That does not also give them the right to have a certificate of occupancy. They have to come to the city to get those. We enforce our own ordinances, not respectfully this court, not the Court of Appeals, not EPD. The city of Stonecrest says whether you meet the standards, whether you comply with our zoning ordinance. Of course, they can ultimately appeal that to the hearing officer, the Construction Board of Appeals, and ultimately to this court. And we will be bound by that. But they haven't exhausted those remedies. That's the exact same thing that they chided everybody who would listen in the solid waste handling permit case. So they should take a dose of their own medicine before coming to the court seeking extraordinary relief. Read our ordinances, follow our ordinances, seek the appropriate appeals. And when you file an appeal, don't dismiss the appeal like you did at Superior Court when you were appealing the Construction Board of Appeals decision. When you file an appeal and Janice Jackson doesn't give you one, then seek mandamus to compel what? A hearing. But they don't want the hearing under the process of the city ordinances. No, what they want is to jump the line, bypass the process, do what they condemn the city of Stonecrest for, do what they condemned Your Honor for, and just give us the license. When they don't comply, we've been telling them for at least 4 years, you violate the zoning ordinance, you're a threat to public safety, you lied on your application. That's why you were denied. So, Your Honor, I think that Metro Green needs to follow the law, the administrative procedures, exhaust those remedies, because as Your Honor knows better than I know, mandamus does not lie when you have adequate legal remedies available to you. And I just spent some time outlining them for the court. Thank you.
All right, give me 1 second. Take a look at 22 CV 1129. Okay, Mr. Robbins.
Yes, Your Honor. As we point out in our brief, the response brief, as you will see, it is frustrating that rather than address our legal arguments, we said that basically it's been name calling from the city or the city's attorney. And I wrote down Mr. Denmark's response to our argument, quote, disingenuous, end quote, patently false, read the code as if we don't read the code, self-congratulatory, hypocritical, self-righteous, shameful, hypocrisy, lying. I mean, this is what we have been dealing with in response to our request to the city to do its job. Mr. Denmark did everything in going on a long discussion of the process of appealing from a denial by the appropriate city administrators of a decision which specifies the criteria, the basis for denial. The problem with that, and the fatal flaw here, which is the basis for mandamus, is the city hasn't done any of that. The city administrators have not denied anything like they were supposed to process and then articulate any bases for denial, which would then allow us to respond to those bases and then appeal if we need to. The city, not us, has refused to honor the city's ordinances as to how applications for a CO or a business license should be handled. It was the city who chose a different way. And Mr. Denmark doesn't even address that. The fact is, the city contrary to what its own ordinance framework says, and which Mr. Denmark went through at length regarding decision-making at the city and appellate process for those decisions, the city has chosen to reject the applications without consideration by staff on purely legal grounds. That has been the only response by the city, and that was through counsel. And the only basis for rejection by the city is not in the ordinance, not permitted by the ordinance, but are a fundamental, I think, mischaracterization of what Mr. Denmark calls a totally different, totally irrelevant Court of Appeals decision. I want that in the record, that the city would even consider what the Court of Appeals did to be irrelevant. Because, as I noted, if you look at Exhibit 13, which is a letter from Mr. Denmark's former colleague, it's 1.5 pages. That is the sole basis that the city has based its refusal to even consider our applications.
Mr. Denmark, other than this Exhibit 13, is there another denial of the application?
Not to this point. And I'm not aware that, from my perspective, I don't even know if that letter from Orlando Pearson qualifies. I mean, under our ordinance, the denial has to come from the city manager or designee. And so that's the process. I mean, it's, council, they rely on the law when it suits them. But I mean, the law also says that the city manager or designee must give the response. But I'm
asking though, Mr. Denmark, when was Mr. Robbins, when did you make the application?
Okay, they're in the files. Let me put you to those. April 19th and May 8th letters, and I'll give you the exhibit numbers, which is the business license renewal was under cover letter dated April 19th to 2024 and May 8th to 2024 when we got no response. We filled out the checklist just like you're supposed to do, and that's hearing Exhibit 12, which is also the petition Exhibit 12. And then the certificate of occupancy issuance demand, which again, everything, and I could go through those exhibits, everything had been approved up until the city decided to litigate.
But not considering the approval process.
Not considering.
I'm trying to determine whether or not you asked for the license based on the zoning, or did you apply for a renewal?
Yes, we applied. The city certificate of issuance demand was applied same dates, April 19th and May 8th, 2024.
And your application.
And we submitted the checklist.
That application and the checklist, Exhibit 12, you're saying?
No, let me just be clear. There are two. Business license was one.
Okay,
that
business license. Mm-hmm.
Application and checklist with the documents attached is hearing Exhibit number 12.
Okay, hold on. Okay. So let me go to 12 real quick. All right, so I have, April 19th, there's a letter the firm represents. Okay. To define and close Exhibit A, Green's application for renewal of its business license. Okay.
There's a May 8th letter too in that same packet because we didn't hear anything. And we submitted it, as you will see, to like everybody possible, since it's not clear at the city who does what. So that's the business license.
Okay, hold on. Let me get to the May, if I see the May 8th letter. Okay, I see the May 8th letter. And the May 8th letter, this is still related to the business license?
Yes, Your Honor.
All right. And then the certificate of occupancy, what time frame is that?
It's the same time frame.
Oh, okay. So those letters include both applications.
Hold on. It's hearing Exhibit 18, which is Brian Easley's affidavit. Brian Easley is counsel who was submitting this. And Exhibit A and C to his affidavit are the completed checklist and application for the certificate of occupancy.
Okay, because on their complaint, the last exhibit I have is 15 on the complaint.
Right. This was attached to, we added additional things, as I mentioned. So we have a complete record. We added last night an affidavit from Mr. Easley attaching these additional records. So everything was there. So that is Brian Easley's affidavit, which is exhibit number 18.
Okay, exhibit 18 on that one. Okay, hold on for a second.
And A and C.
Okay. All right, April 19th. I see it now. All right. And with the application, okay, so with the certificate, you attach the order from the Court of Appeals and And then I think this might be another, the business license application that was attached. Okay. And then the checklist. Okay. All right then. So generally after that, your position is you haven't heard anything other than the letter that you got back from council.
That is not our position. That is the absolute truth. And I don't think Mr. Denmark is denying it. The city, rather than process the applications and consider it on the ordinance criteria, instead had its city attorney declare those applications void ab initio and moot. That's the only basis for the city action. So there hasn't been any action by the appropriate staff by the city, or any denial that can be appealed. The city has chosen to stake its sole position on legal grounds, which are on their face in error. And when he says the Court of Appeals decision is irrelevant, that is most unfortunate, since the city elected to rely on this court's injunction order to declare our applications void on the basis of your honor's injunction, which was reversed. That is just simply wrong.
Okay, so let me go back to you, Mr. Denmark. So do you accept the April 19th and the May 8th letter as their applications?
Yes.
Okay. And generally, according to your according to your ordinances, what is the time frame for you responding to those applications?
That does not come immediately to mind, Your Honor. I'm not familiar with exactly the time frame. I could look it up, but
because your position seems to be that they're not adhering to the ordinances with regard to they're supposed to follow a process for denial. Is it your position that they've been denied or not?
Your Honor, Mr. Robbins takes the position that the letter from Orlando Pearson on May the 10th was a denial letter. Under the city ordinance, you have 15 days to appeal a denial. So if it is a denial letter, and I can see that it is, then they have 15 days under the ordinance to appeal the denial letter, and they didn't do that. So it can't be the case that they hold our feet to the fire with regard to the local ordinance and say you have to do this, you have to do this, you have to do that. But then when we deny on whatever ground we deny it, they say, well, we're going to go outside the ordinance, the city ordinance. We're not going to file an appeal like they did in the past to Janice Jackson's denial. We're not going to file an appeal. What we're going to do, we're going to go to Superior Court. We're not going to avail ourselves of the remedy.
Well, it just depends. I think it depends because have you reviewed the denial letter from council?
Yes, I have, Your Honor.
All right. And so let me, if you all will pull up that letter to the extent you can. I took a look at it. Generally, it seems like the letter is responding to the. I'm assuming that your denial letters normally will reference the reason for your denial in the letter. Like if you are denying it, you're going to put in there the reasons why you're denying it. And that is the basis for which you're using to deny the applications, correct?
I'm not being coy when I say I don't want to represent it. That's what typically happens because I don't know what typically happens. I would imagine that is the case. But Your Honor, I think my position is this. When you get a denial letter, they're going to be good grounds sometimes. They're going to be bad grounds sometimes. And whatever the grounds, good or bad, there's a process to address a denial because every applicant is going to say that they're denying me falsely.
Well, that's what we're getting to the meat of. I'm trying to determine what your process is so that so I'll know whether or not they've done it and or whether or not they need to seek mandamus because they've done as much as they can do. So that's what I'm trying to figure out. So you're going, because you are the city, you're gonna have to help me tell me what your process is. So
yes,
we can't certainly ask them to do a process if you can't tell me what it is.
What I just said is that under 1516-1, anybody aggrieved by a denial of a business license has 15 days to file an appeal with the hearing officer. That's the process. And what I'm saying.
So your position is that this letter is the denial letter?
Yes, that's all there is. That's the denial letter, and they failed to seek an appeal of that denial within the time frame sought in the statute. Now, they can't be heard to say, well, the reason in the denial letter was just wrong. But we thought that, the reason in Director Dunn's reasoning was wrong, but it wasn't whether he was right or whether and I still think he's wrong. But that's not germane. The issue is whether the city of Stonecrest submitted an appeal within 30 days. And our appeal may have been meritorious, it might have been completely meritless, but we don't even look at within the four corners of the appeal to assess its merits unless you have met the filing deadline. That's like saying I missed the statute of limitations, but I had a really good case. Well, you may have, but you didn't file it in time. So I think that what what your being wants to do is to say, well, we didn't file the appeal of the May 10th letter by May 26th as we were bound to. We still haven't, but that the grounds in that letter were no good. So we don't have to adhere to the filing deadline. We don't have to exhaust that administrative remedy like they insisted that the city of Stonecrest did. They're saying that since we assert that the grounds set forth in the May 10th letter from the city were nonsense, but we can just dispense with the filing deadline. Well, what they should have done was file an appeal within 15 days as the code requires, and then they could have argued that those grounds are nonsensical. And if the hearing officer did not agree with that, then they had the opportunity to seek relief in this court by appeal. They said, we're not going to follow that process. What we're going to do instead is we're going to look within the four corners of the denial letter, and if those grounds aren't good enough, we are going to ask this court to dispense with the administrative process, nullify the Stonecrest ordinance, make us not comply with 1516.1, and say, well, those grounds are no good anyway. When they could have made the argument that those grounds are no good to the hearing officer pursuant to a proper and timely appeal. And if the hearing officer didn't agree, then there's a process for that.
Okay, so I think I hear you. Mr. Robbins, his position is that even accepting this letter as a denial process, that there is a process that you must go through,
Yes.
that you cannot skip that process. Their position is if it's the denial, you have 15 days, you go before a hearing officer, you fail to meet that time frame. Regardless of whether they're what they're indicating in here is a good reason or a bad reason, there's still an appeals process because the court case in the original case before the court was dealing with the waste management permit, and this is dealing with a business license, which is very different. And I do recognize that there was a mandamus on that business license, and it was dismissed because I thought the concept was that some of this stuff was so aligned that it did make sense to move forward at that time with the license. I do remember or recall something of that nature. I think Mr. Benson is on the line, so he might chime in on that. But I remember that case got dismissed, and that the parties had come to some agreement. There was some consent on some issues, and it just kind of was like, okay, these matters shouldn't be handled at this point. We should deal with the waste management first before we deal with the other issues of occupancy and the business license. So what is your position on the fact that Mr. Denmark argues that you got a denial and you didn't follow through, yet instead you just came to the court on a mandamus, and their position is they've acted, you haven't?
I understand. The earlier proceeding was a certiorari because there was a staff denial by the appropriate person and an appeal process. And the reason that ended up being dismissed is this, your honor was involved at that time, and the city was taking the position that the injunctions and other relief sought in the case were pivotal to that issue. So that we proceeded to go forward with that other case, and your honor entered the injunctions. But here we're talking about the 2024 applications, and I believe Mr. Denmark has conceded these were correct applications. They were correctly submitted. I don't hear that an objection to that.
That's what he said, that they were correctly applied for. So
it is ironic that the city says we have to file ordinances regarding appeal when the city did not file its own ordinances in considering the applications. Mr. Denmark has conceded that there's no city, that the city administrative people who handle applications for a certificate of occupancy or business license renewals did not issue any response, whether it be approve or approve so long as you do this, or deny, or articulate the grounds. Mr. Pearson's letter on behalf of the city, which is the four corners of the basis of the response to our applications, was very careful not to say whether it was approval or a denial. And we read it many times before we sought mandamus, because what it says was the CO and the applications are void, ab initio, and moot. That's a legal basis. And it was, I mean, we all know how this process works. Mr. Denmark has to know how this process works. He's alluded to it. What we needed to know, what does that mean? That's just a legal argument, but it's neither an acceptance of the applications nor a decision.
So when you got the letter, did you contact?
Yes. I'm sorry, Your Honor, I keep interrupting. I apologize. And I was
wondering if you made contact with him and what was the
reason? We contacted him within 6 days, and that's the email attached to my affidavit. What exhibit number is that? Exhibit number 16 is my affidavit, and there's an email attached from my colleague copying everybody, including all counsel and as to Mr. Pearson, because I read it and I know what a denial is, and I know accepted with conditions. I know what it is to get a report from an administrator saying we are denying it for A, B, C, D, E, F reasons. I know how to deal with that. And so we followed up on May 16th, 6 days afterwards, to ask Mr. Pearson, quote, given this, we are requesting clarification on Stonecrest's position with regard to the applications. Are they denied? By claiming they are moot, is Stonecrest refusing to consider them? We need to know this in order to determine how to proceed and how to present Stonecrest's position to the court.
Okay,
Please.
so
I didn't.
yeah, okay, I get it. Thank you. All right, so Mr. Demark, the Metro Green doesn't have a response. That doesn't have a response to the applications if your position is the application, or is it your position the applications are moot?
No,
What is that?
no, Your Honor. If you're done talking, I don't want to interrupt the court.
I'm done.
Oh, yes, ma'am. My position is that Metro Green has always asserted that the Orlando Pearson letter in their filings was a denial. Your Honor asked me directly, is that a denial? And I said, well, yeah, that's the only response. That's a denial. Then when I brought up the fact that they had 15 days to respond to that denial, and now all of a sudden, well, maybe this letter isn't a denial for the very first time. So, that's the response that they got. They didn't get a license as a consequence of that. That letter represented a denial, and therefore they were on the 15-day clock from there. Your Honor, I must say also that when Council Metro Green submitted their letter in April, they said that if they didn't hear back, it will file this mandamus action. They never said if we don't hear back, we're going to appeal the denial. So they were always intent on doing a mandamus. Now, and let me say this also, Your Honor, when Metro Green dismissed their Superior Court action on the CO, that was based on the pendency of the solid waste handling permit case. Right now, despite what Mr. Robbins says, that case is still pending before the court, and there's been no final order entered in that case. And so
no, that case is not pending before the court. It was dismissed after the consent. I just looked at it after the consent order between the parties. Excuse me.
No, I'm not talking about that. I apologize.
Okay.
I'm talking about the solid waste handling permit case,
Oh.
where they still have. When that case is dismissed, because Mr. Robbins says, well, you guys are dead in the water. There's no place else for you to go. You don't have a move on the board. Well, we've heard that before, but unless and until this court gives a determination that the case is over, then the case is still pending. And they dismissed their CO case in Superior Court because the case was pending, and that case is still pending. So what I would say to the court is, yes, the Orlando Pearson letter was a denial. They were on the 15-day clock at that time. And when Orlando referenced the Superior Court case, he said that there was still a path forward for the city so that the case was not over. Now, Mr. Robbins completely disagrees with that. He thinks there's no path forward for the city of Stonecrest in that case, and he's entitled to that belief and that opinion. That's all Orlando was stating, that there was still a path forward for the city of Stonecrest in that case. He might have been right, he might have been wrong, but that was why the letter said what it said. But nevertheless, I continue to insist that within the four corners of that letter is irrelevant. It denied the application for a business license, and they were on the 15-day clock thereafter.
In your you indicated initially, I haven't seen the ordinance that 15-220 requires the city manager to review the file, but
or designate, Your Honor, or designate. City manager or designate.
Or designate.
Yes, ma'am.
So let's assume that the city of Stonecrest have missed this appeals application for 2024. Is it your position that
you'll need to unlock your iPhone first?
So I don't know why I did that. Is it your position that they have missed the 2024 timeframe altogether?
If they did not timely, and maybe I apologize, I'm misunderstanding Your Honor's question.
They can't like reapply again for 2024. There's no other reconsideration for 2024.
There very well might be, Your Honor. I haven't memorized the code, so I just didn't anticipate that question. So I just don't know what the code specifically says in that regard. But there may be another opportunity for them to seek a 2024 business license. There may be.
Okay. All right. Any final comments, Mr. Robbins? It's your petition out before.
Yes.
Do you wish for the court to consider that? Well, to some extent, I guess it is what it is. The motion to dismiss in your response in this court's decision.
Yes, we filed a response to it. I ask you to consider our response. But the bottom line is this: mandamus is available when city officials don't do their job. Okay, Mr. Denmark outlined a process by which applications are submitted, which we did, conceded that these were applications. The appropriate administrator for the city considers those and then decides whether to grant with or without conditions or deny based on objective ordinance criteria. Okay, that is the process. Then if there is a denial, there is a right to appeal. There is no question in this case that the city has not done its job. They did not process the applications, apparently. I still don't know the answer to my question. By Mr. Denmark's own admission, the city administrators did not issue any opinion, did not issue any denial. All we got was a legal position that they were moot and void. That is not a denial. We know how to say a denial. It is the city attorney saying we're not even going to consider that for legal reasons that are demonstrably wrong. We then went, as my email states, we then asked for the very clarification that Mr. Denmark, for the first time, offers here before Your Honor, which this should be considered a denial. Because we asked, are you refusing to consider them? Are you denying them? Those are reasonable questions for any applicant of a city to ask when a city attorney, not the city itself, just says the applications are void for legal reasons. So for Mr. Denmark to now answer our email by saying it's a denial when it nowhere states in the letter it's a denial is just wrong. So what we're asking, there are two alternatives, Your Honor. One alternative is to compel the city officials, and I still haven't heard from Mr. Denmark who those people are. There's a person or his designee, and I even looked at the website, and you just submit these things online. So that's why we named the city, because who at the city? And we named two officials. But there's two paths to go. There's one is a mandamus requiring the city officials to process, consider our applications, articulate reasons under the ordinances, and then they can have a denial. If they wish to deny for ordinance reasons, we can go through that process. And quite frankly, we would like our fees for being put through this completely wrong approach to it. The second, though, we asked you to consider it, because if there's one thing clear in this case, the city is just going to fight at every single turn to prevent us from lawfully operating. I mean, it's endless. We believe this has to stop. We believe, and there's case law in our brief supporting it, and there's various other cases we can send to you. When a city does not act in accordance with the law and instead takes other positions with respect to licenses or permits, or mandamus must be issued, and those licenses need to be issued. We did everything we were supposed to. That's not disputed by the letter. And the only reasons offered against our applications are legally invalid. If that's not gross abuse of discretion, I don't know what is. It's certainly not any reasons under the ordinances to reject our applications. So we would, so the two alternatives is, one, require the city to do its job, process, make a ruling under the ordinances, and do that. But we strongly recommend the other approach, which is the city had the city had the opportunity to process and act on the applications and offer reasons. It did not do so. And under the law, that's too bad. We're entitled to mandamus on that. So that's our first. So we've offered, Your Honor, two alternatives. What the city can't do is just say they're moot and void. And Mr. Denmark, we were trying to define what was in Mr. Pearson's mind, but that's not a job for any of us. The job for all of us is to look at the city response, what it said and didn't say, and then rule on that. And we respectfully request our fees for having to go through this expensive process, because it's wrong. It was meritless. They didn't do their job to act under their ordinances. And if there's not some consequences to the city, make no mistake, we have counterclaims in the other action, which are serious, the losses are $500,000 a month, and it's been 3 years. And we're just going to deal with the same arguments over and over, denying our right to operate. The Court of Appeals expressly reversed your injunctions denying Metro Green the right to operate. That is fundamental. That is not irrelevant. So those are our positions in this case, Your Honor. And the motion to dismiss don't It doesn't change. They can't add new reasons that had they acted, then they would have found this. That's not legally acceptable. As to the party issue, Your Honor has the right under the Civil Practice Act, of course, to substitute if there's a successor to an official like they argue. Your Honor, that's automatically substituted. If there's some missing official that we might have missed, Your Honor has the right to add such person. But you know, these kind of procedural points beside, we're entitled to action, and we're entitled to mandamus relief for the city's inaction and not following its own ordinances.
Okay, so I have one final comment. So this is a little bit of insight to the, I guess, the questions that the rationale or the analysis that's going through my head. If the position is that the letter is not a denial, but in fact a letter indicating that they're just not going to consider
Right.
application, and then you present them to another person, or another, or through the process, and you get then a list of other reasons, which could be very similar to the ones they gave you in
2022.
What did I do on my notebook? I stuck it over here. If I could just get here to the ones they gave you. Is it your position then that they are stuck with the rationale that they wrote in the letter, or is it your position that they can reconsider their application process? And the reason is because what I don't want to happen is, I think everybody you gotta tell me what your position is going to be. Because if your position is this letter is not a denial, but basically saying they're just not going to consider them, and I ask them to reconsider them, and the consideration turns out to be the same thing you got 2 years ago, I don't want you to come back here and say that in fact they can't deny it, because that's not the reason they gave in the letter, which we've already indicated is not a denial. So that's one, because you got to take one position over the other. And then if my position is that this is a denial, and the only rationale in there is faulty, but you missed the application deadline, but there might be another avenue to travel, but I guess we haven't tried to see exactly what that is. I know you said there may be. I know your position is you don't know if there's another avenue or not. I'm just saying another avenue that you could pursue. But I guess what I'm trying to say is that I don't know if we did so much research on the original case dealing with the things that you can and cannot do, and how you're supposed to handle these applications, the administrative process. And I can't remember the outcome of some of the rulings, but I know one of them is considering whether or not you got a ruling. Like, is this a ruling or not is a big deal. And so I'm going to go back and take a look at that, but trying to determine whether or not this letter is a ruling or not a ruling. But I think it's going to be pivotal to what the court ultimately decides to do. To the extent you want to submit any additional law on that issue, I'm going to give you and Mr. Denmark 7 additional days to do so, because I do think that is going to be pivotal to the determination of whether or not this is a ruling or not a ruling, but a decision. Because if it's a decision and it's a bad decision, then perhaps you have missed your deadline. And the letters last time, I remember that the position is that sometimes just a letter on the letterhead from Mr. Dunn, when he submitted the letter, it was just a letter. It wasn't an official tribunal heading, or there was not even a consideration that you were actually having your matter considered, but that his letter is enough to be considered a denial, even though it wasn't styled as being in a particular case. Like, for example, if you think about the kind of tribunal, the court proceedings where you have someone reviewing it, but if that letter comes back and there is, on official letterhead, the time starts ticking. I remember some consideration for that, because I think at the time, Chase's position was that this is a letter, but the letter did not state yay or nay. It was just a letter. And their position was that it did not do anything. And so the time should not tick. And I think that the Court of Appeals is like, yeah, it's ticking, and so, and I might be mixing up the particulars of it because it's been a moment. But I need to go back through it. And I'm just saying that's why I'm giving you guys 7 additional days, because I want to make sure I want to make the right decision with regard to it. But I did, and I understand what the Court of Appeals did, but I felt like I spent a considerable amount of time trying to understand those issues, and so I don't want to get it wrong. So I'm going to ask that if you wish to do so, you don't have to. You could rely on what you have. I haven't reviewed what you've presented, but if you wish to do so, you can. I'll give you 7 additional days to discuss the potentials of what that letter does or does not do, in light of some of the other positions that were taken in the other case. All right. So if you choose to do that or not, I will wait the 7 days. Well, I won't be waiting. I'll be doing my own research as well. But I will give you that opportunity to do so.
Your Honor,
And I think this is particularly so since your position is that the city was not responsive to your position as to what the letter was.
Right.
Right now, Mr. Denmark is saying you need to respond to that letter. And your time started ticking in. So I'll give everybody 7 days on that issue. Okay.
Could you make it until, when you say 7 days, could it be the week from this Friday? Just, we got the holiday and we can get you something. I almost never miss an opportunity to be heard if the court allows me to. So we will submit something a week from this Friday on the issues raised. And those are, Your Honor, those are very fair questions. I understand the history. Frankly, we don't want to create any more reversible issues. It's been a long time for this plant or this facility not working. We want to avoid reversible issues. You want to, and I hope the city wants to as well. This has gone on too long, just too long. And this is not what Metro Green ever wanted, to have this battle, ever. So we will respond a week from this Friday to the questions that you asked, which are very good. And like I said, we have an equal interest in ensuring there's no more reversible error.
All right.
Your Honor, if I might, Your Honor,
yes,
there's I did not receive, like Your Honor, the response to the motion to dismiss. And so if I may be permitted to do my reply and the question to Your Honor by that week from Friday deadline.
Well, I think in your reply, okay, so generally for what time frame were you trying to do your reply in?
Same time for week from Friday.
Oh yeah, absolutely. You can do your reply and then include in that the concept related to this letter.
Yes, sir. Thank you. Thank you.
All right. Thank you. Y'all are all excused. Thank you so much. Y'all take care.
Thank you, Your Honor.
Thank you, Ms. Harris, if you'll give me a call. Sterling and Nia, if you'll come to my chambers. Thank you.
Please listen carefully. Although you are not physically in the courtroom, you must conduct yourself as if you are in the courtroom. That means no walking, no talking, no one eating, no one in the restroom. You cannot be laying down in your bed. You cannot be laying down on your sofa. You cannot have covers on you. You cannot be using the bathroom. You cannot be getting dressed. Again, you must conduct yourself as if you are physically in the courtroom. If you're going to be outside, you must not be a distraction to the court. You need to be stationary. If you're going to be outside, you need to be stationary. Just sit down somewhere. If you are in your car, make sure that it's obvious that you are the passenger. It needs to be obvious that you are the passenger. If you are behind the wheel, you must pull over now at this time. You cannot drive during this hearing. Even if the judge has not called your name, you cannot drive while you are in court. Again, you must conduct yourself as if you're physically in the courtroom. If you think your background is going to become a distraction to the court, just turn your camera off until Judge Barrie calls your name. When Judge Barrie comes on the onto the Zoom, she's going to give you more instructions, okay? But at this time, if you think you're going to be a distraction to your court, just keep your camera off until Judge Barrie calls your name. Then you turn your camera on. Also, make sure that your speaker is off. Do not turn your speaker on until Judge Barrie calls your name. Do not turn your speaker on until Judge Barrie calls your name. All right. If you are caught violating any of the things that I just said and any other thing that I may not have mentioned that you cannot physically do in the courtroom, the court may remove you from this hearing. If you are removed from the hearing, you may get a bench warrant. If you are removed from this hearing before Judge Barrie calls your name, you may receive a bench warrant. So abide by all the things that I just told you. Conduct yourself as if you are physically in the courtroom. Do not speak out of turn. If you think your background is going to be a distraction to the court, just turn the picture off. Keep it simple. Turn the picture off. At this time, the court needs for everyone to change their name to the name on the calendar. Change the name on this Zoom to the name on the calendar. So if your name is Zoom user or iPhone, you need to change your name to whatever your name is on this calendar. If you do not know how to change your name, you can send me a chat, Rhonda Davis. You can send me a chat, Rhonda Davis, and I'll change it for you. Just let me know who you are on here and I can change your name if you do not know how to change your name. All right. Are there any questions? Any questions? All right.
Yes, I have a question.
Yes.
My name is Laura Smith. My I'm a judge, sorry. My lawyer told me that I don't have to be present today because he did put in a verdict, but I just wanted to be
Wait a minute,
sure.
hold on. No, you wouldn't have a verdict. He put in a waiver. What's your name?
Yes, Laura Smith.
What's your attorney name?
Arca, Howard Arca.
Who?
Arca.
Just
Howard
hold.
Arca.
Yeah, just be on the safe side. Just hold. If you got a
Okay.
waiver, I know that on Judge Barry's calendar. If your
Yeah.
attorney filed a waiver, Judge Barry will let you know that they filed a waiver.
Okay.
I don't have all the waivers right here in my face, so just hold. That is safe
Okay,
and sorry.
thank you. Okay, thank you.
All right. And what? Let me change your name.
Please.
What's your name again?
Laura Smith.
Laura?
Yes, ma'am.
All right.
Were recorded for quality assurance purposes. If you are a service member or the dependent of a service member, please
keep your mic muted until Judge Barry calls your name. Just keep the mic off until Judge Barry calls your name so that you do not become a distraction to the court. Again, if you become a distraction to the court may remove you and you may receive a bench warrant. Just keep yourself on mute until Judge Barry calls your name.
All right, so good afternoon, everyone. This is Judge Tangela Barrie. I'm the judge for Division 10. This is our arraignment calendar. Before we begin, there are a few preliminary matters that the court wants to go over. First, to comply with open courtroom, we are streaming live on YouTube. You should have had an opportunity to discuss your case with your attorney. To the extent you have not. If you're in the jail, we'll give you a phone so that you can do so. And if you're on Zoom, we will place you in a breakout room so that you can have private chats. The purpose of this calendar is to advise you of your rights and for you to enter a plea of not guilty, or remain silent. Prior to entering any plea, there are certain rights that you should be aware of. First, you have the right to counsel. I recommend you have counsel since you're charged with a felony. Please allow me to explain to you the role of an attorney. An attorney has been to law school, passed the bar. He or she knows the rules of evidence. They can discuss the facts of your case, pointing out the strengths and weaknesses in your case, and they understand sentencing. They can give you advice about criminal procedure, but your attorney does not make the final decision about whether the case goes to trial or not. That is your decision to make. Your attorney can explain in detail what I've just summarized for you. So with an attorney, there are a few options. You can hire a private attorney. If you're incarcerated, you automatically qualify for the services of the public defender's office. If you're out on bond and financially unable to afford a private attorney, you may qualify for the services of the public defender's office. I will ask one of the public defenders to speak with you. They'll give you some documents to complete to determine whether or not you qualify for their services. If you do not wish to hire or use a public defender, you might want to represent yourself. The court doesn't necessarily believe that is wise, but if you decide to represent yourself, we'll have a hearing. That hearing is to determine or to ensure that you understand the undertaking, because you will be held to the same standard as all lawyers are. In addition to your right to an attorney, you have other rights as well, such as the right to a trial by a jury. That is 12 citizens determining your guilt or innocence. The right to the presumption of innocence. You do not have to prove your innocence. The state must prove your guilt beyond a reasonable doubt. The right to confront witnesses, the right to subpoena witnesses, the right to testify and to offer other evidence. You cannot be forced to testify. You are the defendant, and you have a right to remain silent and not incriminate yourself. The fact you choose not to say anything cannot be used as an inference of guilt. If you do testify, you'll be testifying under oath and subject to cross-examination. You have the right to assistance of counsel during trial at all stages of the trial. And of course, if you cannot afford an attorney, one will be appointed on your behalf. You can have a jury trial, or you can have a bench trial. With a bench trial, there is no jury. This court determines whether you're innocent or guilty, and if you're found guilty, proceed with sentencing. Under Georgia law, please be advised, you have the right to apply for post-conviction relief. We call that habeas corpus. If you believe that your rights were violated during this process, you'll have 4 years to apply for habeas corpus relief. If you pled guilty or was found guilty of a felony, and 12 months if it was a misdemeanor. Additionally, you need to realize how the resolution of this matter might affect your immigration status. When I call the calendar, if you're on Zoom, unmute and state your name. If you're on Zoom, unmute and state your name. If you're in the courtroom, just please stand. Allow the counsel to make an announcement after you have announced yourself. If you remain silent, you'll be placed on the next jury trial calendar. The court will enter a plea of not guilty and place you on the next jury trial calendar. All pleas of guilty must be freely and voluntarily made. You must not be any drugs, medication, alcohol, or anything that might affect your ability to comprehend what is happening to you at this moment. You must understand what you're charged with, and you must understand your rights. If you plead guilty, you'll be giving up those rights, the very rights that the court just read to you. For example, the right to a jury trial, the right to subpoena witnesses, the right to confront witnesses. You're placing yourself at the mercy of the court, and I will dispose of the case. So again, when you hear your name, open up your mic, state your name so that you can come to the forefront of the Zoom camera for the court. or Zoom platform for the court. And then your attorney will make an announcement behind you. For those attorneys who are asking for a time to apply for motions or to file for motions, that will be granted. We'll give you 10 days to do so. Request that you particularize those 5 days before the pretrial conference. State your name.
Dexter Patton.
All right, who's your attorney?
My attorney is Money King, and I haven't fully paid him, but that's my.
You paid him or you haven't?
Yes, I haven't fully paid him yet. And
So
he's
you
supposed
need
to
to hire.
No, not yet. He's supposed to be showing up today.
Well, he's not supposed to show up if you haven't paid him, but and he hasn't filed an entry. So hold for a second so I can discuss some issues with you.
Okay.
Okay, I'm sorry why I didn't put this up here. So for Akil Bennett, what was the announcement on that? Because that's still on my screen, but I know I called that case.
Judge, she's not on the Zoom, but she's been reaching out to my office about having.
Oh, okay, that's why I kept it there.
difficulties.
Okay, I see. I know why I kept it there now. Okay. And then Laurie Mercedes Smith. Laurie Mercedes Smith. So I have a waiver by Brian Howard on that matter.
Yes, this is Laura Smith.
All right. So your attorney has waived arraignment, entered a plea of not guilty on your behalf. So you're free to leave.
Okay, thank you.
Mm-hmm. All right. So I have two cases made a request to hire. That's Crystal Lee Carter and Dexter Patman. Both of you, please state your name again so I can see you on the screen.
Dexter Patman.
Crystal Carter.
Okay. You both indicated that you wish to hire. The court is going to reset your, allow you to hire an attorney. When you come back on your next arraignment date, you must have an attorney with you. If at some point you decide you don't wish to hire do not wish to hire a private attorney, you can't afford one, you wish to see if you qualify for the services of the public defender's office, you need to speak with them before you come in on that reset date. Okay. Do not come in on the reset date without a private attorney or someone from the or an attorney from the public defender's office. Okay. If you do, you may face contempt of court. The third possibility is to represent yourself. If you decide to represent yourself, you need to file that request or file that in your case. You go down to the clerk's office, let them know, write on a sheet of paper, you intend to represent yourself. Those three things must be done. One of those three things must be done before you come in on your reset date, or you may face contempt of court, which means that the court may take you into custody. Do you understand?
Yes, Your Honor.
Do you understand?
Yes, ma'am.
All right, you're both free to leave.
Thank you.
Judge, I have some updated announcements. He has applied and qualifies, will enter a not guilty plea, waive formal arraignment.
All right, Mr. Cunningham, you're free to leave.